Welcome back to Piercing the Corporate Veil, Lessons from the Docket. I'm Professor Seth C. Oranburg. We've journeyed through foundational concepts, core tests, LLC specifics, reverse veil piercing, horizontal piercing, and parent-subsidiary dynamics in veil piercing. Today, in Episode 7, we're going to examine some of the forefronts, some of the modern applications of veil piercing, focusing on how these doctrines are trying to adapt to contemporary business models like the gig economy and complex financial structures. We'll take a look at some recent cases, highlight some ongoing legal questions, and look at real-world implications to prepare for our finale in Episode 8. Modern veil piercing often intersects with innovative industries where traditional corporate boundaries are already blurred through novel technologies or globalization. Let's start with a high-profile case illustrating the gig economy challenge, Doe versus Uber Technologies. This is a 2021 decision from the California Court of Appeals, with elements still pending in related litigation. This case involved Jane Doe, who was allegedly sexually assaulted by an Uber driver during a ride. Doe sued Uber Technologies, arguing the company should be held vicariously liable for the driver's actions, despite classifying drivers as independent contractors. Uber's business model relies on a complex structure of subsidiaries and holding companies, with drivers operating via app-based controls like algorithms, ratings, and policies. Doe sought to pierce the veil, claiming Uber exercised such domination, evidenced by centralized fare setting and performance monitoring, that the corporate form shielding the parent from accountability for foreseeable harm should be dismissed. The court analyzed alter ego factors, including the unity of interest test, allowing claims to proceed amid ongoing debates on contractor status. This represents a pending legal question rather than fully settled law, but the fact that the claim proceeded is itself interesting because it suggests that there's a possibility of tort victims in app-based services to push for piercing when harms arise from decentralized operations. Shifting to financial fraud, let's look at Enron Creditors Recovery Corp. v. Alfa, which is part of the broader Enron litigation saga, which has been going on a long time. Enron's collapse in 2001 exposed massive accounting fraud, leading to numerous lawsuits. In this 2011 Second Circuit decision, creditors sought to recover early redemptions of commercial paper, arguing they are fraudulent transfers avoidable in bankruptcy. And by the way, we talk about this more in my financial literacy series. Enron operated through a web of subsidiaries and special purpose entities that were designed to obscure debts and to inflate assets. These structures invited veil piercing across affiliates. The court considered whether Section 546E of the Bankruptcy Code's safe harbor protected these payments, and it ultimately ruled in favor of the banks. However, the case underscored veil piercing's role in complex financial structures, where parents use subsidiaries to isolate risks, similar to horizontal piercing in Episode 5. Note the Enron litigation's overall complexity, involving multiple related cases and settlements, illustrate broader challenges in unwinding fraudulent corporate groups and echoing some concerns about commingling. These modern examples show veil piercing evolving with technology and finance. In the gig economy, courts grapple with algorithmic control as a form of domination, potentially adapting factors like commingling to digital integration. And these are risks amplified in LLC-heavy platforms. In finance, piercing targets opaque entities that evade oversight, building on some concepts of regulatory direct liability. So practically, businesses must monitor for emerging trends, increase scrutiny in tort-heavy sectors where involuntary harms drive piercing, and statutory tools that facilitate disregard without full traditional veil-piercing tests, all underscore a policy of preventing externalization of risk while encouraging innovation through clear boundaries. As we conclude, these applications demonstrate veil piercing's adaptability and hopefully will assure accountability and innovation in new contexts. So some key takeaways for today. Gig economy cases like Doe v. Uber test control and platform models, and we don't know the answers yet. Enron v. Alfa highlights financial fraud's complexity. Modern piercing is trying to adapt to technology and finance. Regulatory intersections make this even more complex. And all of that sets us up for how to prevent veil-piercing risk, which we'll talk about in our final episode, episode 8. And until then, I thank you for joining me. I'm Professor Seth C. Oranburg, and this has been Organized.